Tonight, we're going to take a look in Washington where the Supreme Court justices heard arguments today surrounding an employee discrimination case. It involves Abercrombie and Fitch. Now, a woman says she applied for a job there but didn't get it because she wears a religious headscarf. Where should the line start and stop when it comes to employee discrimination based on appearances? And former New York State Assembly Speaker Shelley Silver arraigned on federal corruption charges. Silver says he's confident he will be vindicated. However, his attorney says U.S. attorney and the media, they've damaged Silver's chance for a fair trial. Does Silver have a shot at one? And what determines whether a trial has or hasn't been tainted before it's even begun? Plus, we're going to dive into the issue of judicial elections. It's a popular process across the country, but the question is it the best way to really put men and women behind the bench? Good evening, everybody, and welcome to RFL. I'm Richard French. Thanks so much for joining us. And tonight, of course, as we do on Wednesdays, we discuss all things legal here, and we got a great legal team to help us weigh in a whole number of topics, and we're also going to have a little fun here tonight. Jim Koutsouras, he's a criminal defense attorney in Manhattan. He sits on the board of directors of the New York City Criminal Bar Association, frequently lecturing at New York Law School and the Bar Association in both Queens and New York City, and he's also a visiting professor at the University of Birmingham in England. Doug Van Oist, a founding partner of Carsten Van Oist, focusing on corporate misconduct and selected by the Legal 500 as one of the most influential trial lawyers in the whole country. Mayo Bartlett joins us. He's an attorney at the law offices of Mayo Bartlett PLLC and former chief of the Bias Crimes Unit at the Westchester County DA's office. And Mark Furnish, here, a Brooklyn law professor recognized as a super lawyer, and yes, we like calling him that. He's argued before the U.S. Supreme Court apropos of our subject today, and he was recently named Criminal Lawyer of 2014 by the Institute of Jewish Humanities. All right, today we're going to start off at the nation's highest court, where they heard arguments in a case involving, as I mentioned, employee discrimination. Now, Samantha Elouf, who's a Muslim American, and she wears a hijab, or religious headscarf, says that she wore the scarf to an interview with Abercrombie and Fitch, and she received a high grading on her interview performance. However, she didn't get the job, and she says it's because of the fact that she wears the scarf. Now, Abercrombie says they never said, or she never mentioned, that she would need religious exemptions, and that it's hired people who are religious and wore religious garb in the past. Now, the U.S. High Court seeks to answer the question of whether prospective employees must explicitly ask for a religious exemption. And we're going to change things up here a little bit today. And we're also, a little bit later in the program, going to go beyond just this single case and ask the broader question about whether or not employers should be able to make determinations on the appearance of a prospective hire or even of a current employee if they believe it damages their bottom line. But what we decided to do today with two of our panelists is have them play attorneys here, and as if they were arguing before the court. And believe me, the other two guys are going to have a loving time here, busting their chops a little bit later. Now, speaking for the plaintiffs and the defense in this case, you got Jimmy Koutsouras, who's going to argue in favor of Ms. Elouf, the applicant in question here, and Doug Van Oist, he will argue for Abercrombie and Fitch, where he shops all the time here for his hot little clothes. All right, let's begin with Jimmy Koutsouras. Jimmy.
May it please the court, my name is James Koutsouras, and I represent the Equal Opportunity Commission on behalf of Samantha Elouf in this matter. We respectfully submit that the Circuit Court's reversal of summary judgment in favor of our client was an error for two reasons. First of all, factually, it cannot be said that our client's hijab in any way violated the stated look policy which prohibits caps. Second, it was an error to place the burden of asking for a religious exemption on a prospective employee who has no reason to think she should ask for one. If a public company wants to dictate how people dress and look then when a prospective employee appears with an article of clothing that's unacceptable, the company must inform the person of it. Otherwise, the person has no idea that what he or she is wearing is against policy. The policy by its terms does not prohibit the use of a hijab, and the facts herein make it abundantly clear that Abercrombie purposefully declined to mention this when interviewing our client because they had no intention of hiring a Muslim woman. They certainly did not want to have to be confronted with her request for an exemption, because then they would have needed to deal with that. People who interview for a job do not normally come to the interview dressed for the job they're seeking. How can it be proper for her to be denied the job without first advising her that it was unacceptable to wear what she was wearing, when the policy, as it is written, does not prohibit this particular headwear? The policy prohibits caps, and there is no reading of the English language which supports a conclusion that the hijab falls within the ambit of a cap. We all know what a cap is, and there's no reason for our client to have known that her hijab was contrary to the policy. Now, citing the 10th Circuit, to Abercrombie, a model who violates the look policy by wearing inconsistent clothing, quote, inaccurately represents the brand, causes consumer confusion, fails to perform an essential function of the position, and ultimately damages the brand. Your Honors, I ask, can it truly be said that a young woman who otherwise dresses and comports herself with this policy is inaccurately representing the brand? We would submit only if she's a Muslim wearing a sign of this on her head, because otherwise there's nothing in this young lady's comportment to justify such a conclusion. The conclusions of the Circuit Court to the contrary cannot be embraced by this Court, as they are in derogation of Title VII of the Civil Rights Act of 1964. Abercrombie and Finch should not...
Okay, I gotcha. Now, let's bring in the other guy, because those dings here, of course, Jimmy, as always, here goes by his own set of rules. I know. Well,
I heard him.
Yeah, we heard him. All right. Thank you. No, we're just kidding. Okay. Mr. Von Oist.
I don't see my face. Oh, there we go. Abercrombie and Fitch.
I win.
Abercrombie and Fitch should not be held liable for rejecting a Muslim job applicant based on her wearing traditional head covering known as a hijab. The job applicant is not covered by the Title VII of the Civil Rights Act of 1964 because during her job interview, she failed to tell the Abercrombie interviewer explicitly that she wore the hijab for religious reasons. Abercrombie has a look policy that prohibits employees from wearing head covers. This prohibition is based on cultivating a classic East Coast collegiate style. The prohibition is religion neutral. The company has the right to conduct its business as they see fit as long as they do not discriminate for reasons of race and religion. Abercrombie is willing to accommodate employee and applicants' various individual religious practices, but making such accommodations is not straightforward. The EEOC's guidelines reflect the difficulty in figuring out what specific religious accommodations are needed. That's why, generally, the employee or the applicant has the duty to ask for the accommodation. It should not be the employer's duty to guess. This is not an unreasonable burden to be placed on the employee applicant and relieves the employer from having to be an expert in the subtle practices of all the religions of the world. Putting the burden on the employer to uncover what religious accommodation an employee applicant requires would unfairly expose them to lawsuits and damage awards without the necessity of showing intentional discrimination. Any accommodation for a religious practice can only occur when the employers know that the accommodation is necessary, and the employee applicant is in the best position to convey this information. The employer should not be put in the position of being a detective with the job of finding out what the individual religious practices are of its employees and applicants.
And he did it under time. I know we had a format. I'm already throwing it out the window, guys. We're going to let these two guys grill them a little bit, and then on the other side of the break, I'll broaden this conversation. Mr. Bartlett.
Mr. Von Oist, would you have the same policy if it was an individual wearing a yarmulke?
Absolutely.
Okay. And do you acknowledge that there are people in society who are marginalized and who feel that they have to basically almost hide who they are, because if they come in openly as a Muslim, that they may not get hired?
Do I acknowledge that those people exist? Definitely.
Yes. So do you think that you're putting a burden on those people by having your policy?
No, because you're actually ignoring the fact that this person's actually looking for a job there. They're going to exist at that place for a long period of time. This isn't a one occasion. So if there's going to be a relationship between employer and employee, they have to both come to a meeting of the minds, so to speak. And if one party needs something, they need to convey that and see if it can be accommodated.
Well, Mr.
How
Von
can they
Oist,
ask
though,
them to
wouldn't it
convey
be
that when it's undisputed that your company knew what she was doing and that she was wearing it for religious reasons? Wouldn't that just be an exercise in formality when it's undisputed on this record that the company knew exactly why she was wearing the headscarf?
Well, you know, in this set of facts, it turns out that the company was right. Can you imagine if the company assumed this person had certain religious needs? Can you imagine what would happen if they said, we just assumed you needed this because of your
what would
religion?
be wrong with that? You could make that assumption if you have a categorical policy of barring anybody with something on their head for whatever reason, as long as it's religious neutral. You knew what the religion was and you have a neutral policy. Why would that be a problem?
Well, in here you're looking for a bright line rule. You're looking for something people can rely upon. And you're asking one of two things. You're asking either the employee to guess and guess what the accommodation should be, or you're asking the potential employer, the employee or the applicant, to come forward and say it. So you're really looking to the court to set a rule. And the
suppose we rule in your favor, then what happens? Suppose we rule in your favor. Don't you, and I guess this is better addressed to your adversary, doesn't he have a right to have a bona fide occupational qualification? They have a brand image that they want to uphold, and it doesn't matter if the person's wearing a yarmulke, a Rasta hat, a hijab, or even a baseball hat. It's inconsistent with the brand, and that hurts their image and their sales. What's wrong with that?
They absolutely have a right to have those demands, but what everybody is missing here is they have to communicate it to the person. So
why do
first
they have
of all,
to communicate it to the person? You don't have a right to know why. They have a facially neutral policy, and you don't have a right to know whether they're following their policy.
But Your Honor, the case has to do with who needs to tell who what, and requiring an employee to come forward and say, I wear a hijab for religious reasons, when the employee has absolutely no reason to think that it's violative of the policy, with all due respect,
is there any evidence in the
counterintuitive.
record that she would have removed the hijab in order to get the job?
There is no such evidence because nobody bothered to ask. What happened here was she's interviewed, she's told no nail polish, she's told no heavy makeup, none of which she's wearing, by the way, and she leaves. She gets scored in a way that she should get the job. When it goes to the district manager says, oh, hijab, no good, she can't be hired. She has no reason to think
So we should
violative.
send the case back to see if she'll take the headdress off?
What I think should happen, first of all, is that summary judgment should not have been granted. There were triable issues here, and as the courts throughout the country have said, these discrimination claims really depend on the facts. So these bright line
So then she
rules are
refuses to
difficult.
take it off, then what happens?
If she refuses to take it off, then it's a violation of Title VII because Title VII
Why? If they won't hire anybody who refuses to take it off, Muslim, Jewish, baseball fan, or Rasta, why is that a violation of Title VII?
What happens then, what gets kicked in, is the reasonable accommodation standard, and then there are three prongs to that need to be addressed in litigation.
But do they have to make a reasonable accommodation, even if it's not religiously based, even if it's just somebody wearing a baseball hat?
Well, if you take out the religiously based, then it's a different story. The reasonable
What's the
accommodation.
evidence that it was religiously based as just a no hat, no headdress policy?
Mr. Von Oyst, what would have been the harm in your client simply asking this individual if she had a religious basis for wearing a headdress?
Why should they have to do that? When she has the religious need, why wouldn't she?
You didn't know that at the time, did you? So she never was given an opportunity
if I could,
to even
Justice
discuss
Bartlett
this.
here, and I love.
Well, you're the chief
It's
justice.
so nice. It's so nice for you to sit here and shut up and watch. All right,
Well, you're like Clarence Thomas. That's what happened.
I have so many places I could go. All right, head over, please, at home here at Facebook and Twitter and sound off on our question as it relates to employee image. And I'm going to get to this on the other side of the break. Should employers have a say over how employees look here? And when we come back, we'll discuss the issue of employee discrimination, whether it be tattoos on the neck, what they're wearing, what their hair is. Should it depend on the line of work here? Where should the line be drawn? We'll get into that after this.